Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan, dan salam sejahtera bagi kita semua. Salam Pancasila. Good morning, ladies and gentlemen. Welcome to the public lecture and collaboration ceremony between Universitas Pancasila and Nicolaus Copernicus University, Poland. We are deeply honored to have you with us today for this special occasion, Trends and Challenges in Constitutional Law in the Era of Modern Democracy, Perspective from Poland and Indonesia. Today's event celebrates not only the spirit of academic exchange, but also the strengthening friendship and collaboration between our two esteemed universities. Before we begin, allow me to extend our warmest greetings and highest appreciation to our distinguished guests. From Nicolaus Copernicus University, Poland, Professor Magdalena Barwielwak, Vice Rector for International Relations, Professor Maciej Serowaniec, Dean of the Faculty of Law and Administration, Professor Arkadiusz Javan, Director for English Division at Collegium Medicum, Ms. Katarzyna Pawłonka, Senior Specialist at the Department of International Partnership and Educational Mobility. And from Universitas Pancasila Indonesia, Profesor Dr. Adnan Hamid SHMHMM, Rektor of Universitas Pancasila, Profesor Dr. Insinyur Ari Setyanto Nugroho, MM IPU CMA MSS, Vice Rector for Learning, Research, and Collaboration, Profesor Dr. Sri Widyastuti SEMM MSI, Vice Rector for Human Resources, Mr. Muhammad Rizky Aldila SHMKN, Vice Rector for Student Affairs, Public Relations, and Legal Affairs, Profesor Dr. Edi Pratomo SHMA, Dean of the Faculty of Law, Universitas Pancasila, and his board, and to all of the head of the study programs and directors within Universitas Pancasila. We are delighted to welcome each of you whose presence adds great honor and meaning to this academic gathering. To begin our event, we kindly invite everyone to stand and sing together the national anthem of Indonesia, Indonesia Raya, and followed by the hymn of Universitas Pancasila. Ladies and gentlemen, please rise. And please be seated. Next, we are truly honored to invite Professor Dr. Insinyur Arie Setyanto Nugroho, MM, IPU, CMA, MSS, Vice Rector for Learning, Research, and Collaboration to deliver the opening remarks on behalf of the Rector of Universitas Pancasila, Professor Dr. Adnan Hamid, SHMH, MM. Ladies and gentlemen, please join me in extending our highest respect and warmest welcome to Professor Dr. Insinyur Arie Setyanto Nugroho to deliver the opening remarks on behalf of the Rector of Universitas Pancasila.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, distinguished guests, colleagues, and students. On behalf of the Rector of the University of Pancasila, it's my honor to welcome you into the public lecture, Trends and Challenges in Constitutional Law in the Era of Modern Democracy, Perspective from Poland and Indonesia. First, allow me to extend our warmest welcome to our esteemed guests from Nicolaus Copernicus University, from Torun, Poland, Professor Magdalena Barbiolek, Vice Rector for International Relations, Professor Masis Serowajniak, Dean of Faculty of Law and Administration, Professor Arkadius Javian, Director for the English Division at the Collegium Medicium, and then Mrs. Katrina Paslonka, Senior Specialist, Department of International Partnership and Educational Mobility, and also Professor Edi Pratomo, Dean of the Faculty of Law, and Professor Chala, Dean of Faculty of Psychology, and all the representatives from the faculty in the University of Pancasila, and also the moderator, Mr. Fritz. Yeah. So, the presence of our esteemed guest from Copernicus, Nicholas Copernicus University, reflects a shared commitment to deepening academic cooperation and people-to-people ties between Poland and Indonesia. Colleagues and friends, today's lecture is valuable for three reasons. First, comparative learnings. We can examine convergences and differences in our constitutional experiences, drawing practical lessons from each other's reform and jurisprudences. Second, policy relevances. We connect doctrine to real issues: election integrity, emergency power, human rights enforcement, and the constitutional implication of technology. Third, the partnership building. We open doors to joint research, co-teaching, student and staff mobility, and potentially dial or joint programs across the law and health sciences, leveraging the strengths of both our universities. As the Vice Rector for Academic Research, Cooperation and Research, I wish to underscore our university's readiness. First, facilitate faculty exchanges and visiting lectureship. Second, expand credit-bearing student mobility and shorts program. And third, explore joint publication, policy briefs, and comparative case studies. And also, to our students, please seize this opportunity, listen carefully and compare framework, and ask courageous questions. The quality of Indonesia's legal future will rest in no small part on the intellectual honesty and civic spirit you bring to the discussion like this. Once again, to our distinguished guests from Poland, welcome to the University of Pancasila. We hope you feel home at our campus and in Jakarta, and that today's exchange will mark the beginning of an even stronger and enduring collaboration. Thank you, and have a productive session. And with the name of the God, Bismillahirrahmanirrahim, I will commence this session officially open. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Professor, for your insightful and inspiring opening remarks. Your message has beautifully captured the spirit of today's event, emphasizing the importance of academic collaboration, innovation, and shared commitment to advancing education in an increasingly interconnected world. We will now proceed with the signing ceremony of the letter of intent between Universitas Pancasila and Nicolaus Copernicus University, Poland. The ceremonial signing represents not only a formal partnership, but also a shared vision to foster academic, such as conducting joint research in the fields of interest to both institutions, exchange of expertise between academic and research staff, exchange of science publications, academic scripts, textbook and literature, exchange of academic and research staffs and students, organization of joint scientific activities, and any other activities which may be incorporated into this memorandum in the form of Annex Hereto. To Professor Edi Pratomo and Professor Magdalena Barviawek, the floor is yours. And to Professor Dr. Insinyur Ari Setyanto Nugroho, you may send the placard. To commemorate this memorable occasion, we will now have a group photo session in front of the stage. We kindly request the signatories of the letter of intent to remain at the front as we capture the significant moments. We also invite the representatives from Nicolaus Copernicus University, the vice rectors of Universitas Pancasila, the deans, vice deans, head of the study programs, and directors to please come forward and join the front area to accompany the LOI signatories for the group photo. For all other distinguished guests who have not yet come forward, you are warmly welcome to join and accompany them for this photo session. Thank you very much. We truly appreciate your participation. Please return to your seats as we continue with the next agenda. Next, on our agenda, we are deeply honored to invite the Dean of the Faculty of Law, Universitas Pancasila, Professor Dr. Edi Pratomo, SHMA, to deliver his keynote speech. Prof. Edi Pratomo is currently nominated for the position of judge at the International Tribunal Law of the Sea. To Professor Edi Pratomo, the floor is yours.
Professor Pratomo received his bachelor's degree in law from Universitas 17 Agustus 1945 in Jakarta, Master of Arts degree from St. John University in New York, Doctor of Law from Universitas Padjadjaran Bandung, and Professor of the Law of the Sea from Universitas Diponegoro, Semarang. Currently, Professor Pratomo holds the esteemed position as the Dean of the Faculty of Law, at the Universitas Pancasila in Jakarta. Professor Pratomo is an experienced individual in the field of law of the seas, treaty law, diplomacy, and international politics. Hailing from Indonesia, the world's largest archipelagic state, Professor Pratomo offers a unique and invaluable perspective to ITLAS regarding the law of the sea and maritime delimitation. Professor Pratomo's career reflects significant accomplishment in both academic and diplomatic spheres. Indonesia believes that Professor Pratomo's extensive expertise and strategic vision make him exceptionally well suited to serve as a judge on ITLAS, where he would significantly contribute in fostering the fair and effective resolution of maritime disputes worldwide.
A very good morning to all of you, distinguished guests and participants, colleagues, faculty members, and dear students. First of all, it is my honor, my privilege to be here to extend my warm welcome to our guests from University of Copernicus in Turun, Poland. It is indeed a great honor for the Faculty of Law to be appointed as the host of these very dignitaries guests from Copernicus University in Poland. I'm here as Dean Faculty of Law, and I'm accompanied by my Vice Dean. Let me introduce my Vice Dean, Ibu Dr. Zaitun Abdullah. Ibu Zaitun, can you just stand? Yes, thank you. Ibu Zaitun is Vice Dean for Academic Affairs. And I would also invite Dr. Yoyo Arifandari, Vice Dean Second. He is responsible with the human resources and financial affairs. And the last one is Dean, Vice Dean Dr. Lisda Samsumardian. She is overseeing the students and alumni relations. I'm also very happy and recognize the presence of Dean Faculty of Psychology, Professor Chala. Thank you for your coming, Prof. Chala. So we have a guest, and I have also Vice Dean of the Faculty of Engineering, Ibu Dini. Thank you, Ibu Dini, for your coming. I think we recognize also the presence of the chairman of the study program. Ibu Dr. Rina is chairman of the study program of graduate program Sarjana, graduate studies. She is Dr. Luhrina, and I have also to introduce Ibu Teti Samusir. Ibu Teti di mana? Yes, Ibu Teti is chairperson of the notariate program study, and I don't have here chairman of the study program of doctoral degree. Distinguished guests, ladies and gentlemen, today is a very special event, because it is not only discussing about academic experience and exchange, but we need also have decided to continue with the collaboration with the Cornelius Copernicus University in different fields. We have just witnessing the signing ceremony of the letter of intent. We call it letter of intent because we will continue to further finalize with the final agreement in a very comprehensive way. Now the letter of intent only consisting of 3 issues. Number 1 is on education, relationship and cooperation for mutual benefit. The second one is the research activities. We will have a joint project on research activities. We will also organize many international seminar. We'll invite also both Pancasila University and also Copernicus University. The last one will be the community services for Indonesian people and for Poland community. Distinguished guests, let me first of all thanks once again, and I express my deep appreciation and gratitude for your choice to stay and to visit us at the Faculty of Law Universitas Pancasila. You have just been to Udayana University and then you visited us today. It is a good opportunity for both of us to open more collaboration in the future, especially in the 3 areas that we are just discussing outside. Excellencies and distinguished guests, ladies and gentlemen, I think in the era of digital era, I think we need to further have collaboration with European University, and today we choose Copernicus to be our foreign partner in Europe, especially in Poland. We would like to continue with the exchange of lecturers, with the initiation of conducting seminar, research, writing project, both of us. And we need also to reciprocate your visit. Next time I will invite Vice Rector Professor Aris to visit this university in Poland. Pak Aris, I will be coming in your visit to Poland in the near future to sign the MOU of our both universities. Distinguished ladies and gentlemen, today is Friday, so I do not want to prolong the statement, but I have already prepared my PowerPoint, my presentations, and I will share it to all of you, especially for our guests from Copernicus University, so that you may understand very correctly the development of our Faculty of Law at the Pancasila University. We explain everything about the story, the historic transformation of our Constitution. Since 1998 until 2002, we have already been amending 4 times of the Constitution. We are now facing many new challenges, modern challenges, especially in how we implement the democracy in the modern era in Indonesia. We are very happy to have a new constitutional court which has very crucial role now. The MK, Mahkamah Konstitusi, is as an institution which is very strong. Yeah, they have to settle the dispute of the general election. They will also conduct a judicial review on certain national regulations. And in the future, I think the constitutional law is very much essential for our students, both in Copernicus and also in Universitas Pancasila, because the constitutional law is the backbone of the democratic governance in many parts of the world, including in Poland and also in Indonesia. So we share the happiness today to receive a guest from our partner, Copernicus University, and we would looking forward to having more collaboration for mutual benefit among those two parties, Universitas Pancasila and Copernicus University. I would like to finish my statement by welcoming you again very warmly. Feel free at this university, and I would like to listen carefully to the presentation that Mr. Majid would like to present on your experience, especially on how the theory and the practice, the implementation under the principle of democracy in your country, especially post socialist model of democracy in your country. It was in the 20th century. You are entering the transformation first, then we follow you in 1998, that we have already amended our constitution 4 times. We are now one of the biggest democracy in the world, and we are the biggest in ASEAN. So I think that is the experience of Indonesia, especially in the implementation of constitutional law. And we have a very strong institution, new institution, namely a constitutional court that is very busy. Every day they are conducting many meetings on the judicial review to review several regulations. Thank you very much. Those are my speech, and I would like to congratulate for the participant, dear students. Please follow and continue listening very carefully with the lecture, and you may also ask the questions to the speaker. Thank you once again. Salam Pancasila. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much to Professor Edi Pratomo for such an enlightening and inspiring remarks. Your message has set a thoughtful foundation for today's discourse on the evolving landscape of constitutional law and has reaffirmed our shared commitment to upholding democratic principles and fostering academic collaboration across nations. Ladies and gentlemen, we are proceed to the highlights of today's program, the International Guest Lecture, Trends and Challenges in Constitutional Law in the Era of Modern Democracy, Perspectives from Poland and Indonesia. This session will be moderated by Dr. Fritz Edward Siregar, lecturer in Constitutional Law at the Faculty of Law, Universitas Pancasila. Dr. Fritz earned his doctoral of juridical science from the University of New South Wales, Australia, and holds a Master of Laws from Erasmus University Rotterdam, the Netherlands, as well as a Bachelor of Laws from Universitas Indonesia. He has also been a visiting scholar at Boston College Law School and the University of Chicago Law School. Dr. Fritz previously served as a member of the Election Supervisory Board of the Republic of Indonesia for the 2017 to 2022 period, and as Deputy for Information Coordination and Evaluation at the Presidential Communication Office. He also gained valuable experience as a judicial assistant at the Constitutional Court of Indonesia and at the High Court of Australia in Canberra. Beyond academia, Dr. Fritz is an active writer in the field of constitutional law and electoral justice, and today he will guide us through this important academic discussion. Our distinguished speaker for this session is Professor Maciej Serowaniec, full professor at the Department of Constitutional Law, Faculty of Law and Administration, Nicolaus Copernicus University in Torun, Poland. He serves as the principal investigator of the Individual Research Project, Supreme Audit Institutions in the Constitutional System of the Member States of the European Union, funded by the National Science Center of Poland. Professor Serowaniec has also participated as a coordinator and investigator in major European research initiatives, including responding to emerging dissensus, supranational instruments and norms of European liberal democracy, and Better Knowledge for Better Solutions, funded by the European Union's Hercule III program. He is a laureate of the scholarship of the Minister of Science and Higher Education for Outstanding Young Scientists, and a member of ICON-S and the Scientific Society in Torun. With such an impressive academic credentials and deep expertise in the field of constitutional law, Prof. Zero Vaniek will share his insights on the trends and challenges in constitutional law in the era of modern democracy, drawing from both European and Indonesian perspective. Ladies and gentlemen, please join me in warmly welcome our moderator, Dr. Frits Edward Siregar, and our honorable guest speaker, Professor Dr. Maciej Zero Vaniek.
And I will. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan salam sejahtera untuk kita semua. Good morning everyone. Thank you for coming to Indonesia, Prof. Maciej, and Prof. Dean, and Prof. Vice Rector, and all the professor and lecturer, and all the students. So I will try to combine between. So do you prefer all in English or you prefer some Indonesia, some English? All English. Oh, good, good. So Pancasila. So there is not it for translate to Indonesia, yeah? So friends and all the students, thank you for your coming. Today we are very happy to welcome and to get all our guests from Poland, from Amace and all our guests from the Poland. Students, what we need from today is how we try to understand constitutionalisms and the trend and the challenges. As you already know, teman-teman, that there is also very similarity between what happened in Poland and also in Indonesia. In 1998, when the Poland left the communist era, they also established constitutional court. And also in Indonesia, after we part of the Orde Baru regime, we also established constitutional court. Poland make the new constitutions, Indonesia also make new constitutions. 20 years later, I think it's more than 20 years later, after 25 years later, now we are here. And what is the story from Poland and what is the story from Indonesia? Can we learn from Poland? Or also, can Poland learn from Indonesia? So this is the point of our discussion today. So I hope you can enjoy. And I think there is no introduction for Prof. Maciej because there is also already in introduction. Now I give the floor to Prof. Maciej. Prof. Maciej, the floor is yours. And let's give applause to Prof. Maciej.
Assalamualaikum, selamat pagi, merhupan sautu kehormatan besar bagi saya untuk memberikan kuliah kepada Anda hari ini. I hope I don't make a big mistake in Indonesian. I'm sure that during my next visit I will try speak a little bit more in Indonesian, but it's not easy language, probably as the Polish language. So I'm very honored to give you today a lecture about the old challenges connected with the Polish constitutional law. So our constitution was established in 1997, but the history of the Polish constitutionalism is a little bit longer because we established the first Polish constitution in 1791. So the Polish constitution was the second of the world and the first in Europe. So we have a very rich history of the constitutionalism in Poland. So maybe only France has a richer tradition of constitutionalism than Poland. As Mr. Dean told you, Polish constitution was established in 1997. So it was after the transition period, 1989, start the transition period in Poland. The communists lost the first free election in Poland, and after then the democratic opposition start to work how prepare the new constitution of Poland. Of course, the new constitution should base on the principle of separation of power, because it's the crucial regulation, crucial principle in the democratic states. And in our current constitution, the principle of separation of power is expressed in Article 10 of the Polish constitution, which states that the system of government of the Republic of Poland shall be based on the separation and balance between the legislative, executive, and judicial power. So it's expressed directly the check and balance principle, like the Indonesian constitution. And in the paragraph 2 of this article, they explain which state authorities waste the power. So according to the Polish constitution, the legislative power is wasted by the Sejm and the Senate. So it means that we have the bicameral structure of the parliament. So it's a little bit different than in Indonesia. Why? I try to explain a little bit later. The executive power is wasted by the president and the Council of Ministers. And in this point, it's very important to underline that Poland introduced the parliamentary cabinet system. It was a big discussion during work on the constitution which system we should choose. The first democratic chosen president, Lech Wałęsa, would like choose the presidential system, like in Indonesia, like in the United States. But he was in the conflict with the parliament. So the majority in the parliament would like to weaken the position of the president and improve the position of the Council of Ministers. So they finally decided to choose the parliamentary cabinet system with some elements of the German solution characterized by the cancellery system. And of course, the judicial power is wasted by the courts and the tribunals. As Mr. Dean told you before, we have the Constitutional Tribunal. We have also the State Tribunal, which play a crucial role in the accountability procedure of President, member of the Council of Ministers, and so on. So what is also very important to explain about the main principle of our Constitution. If we can go to the next slide. Our Constitution also express the obligation to cooperation between all authorities. When we're working on our Constitution, the Constitutional Assembly thinking that this obligation to collaboration will dissolve all problems, that there will be no concurrence, no conflict between the President and the Council of Ministers. So they decided to express directly the idea of cooperation in the Constitution. In theory, it should work, but in practice, unfortunately, in many cases, especially in this, when we have a situation with the cohabitation between the President and the Council of Ministers, they never take into account the principle of cooperation, and many times the Constitutional Court must help to dissolve the conflict between the constitutional authorities. If we can go to the next slide. Also, it's very worth to underline that the Polish Constitution expresses the principle that the Republic of Poland shall be a common good of all citizens. So it's very important provision which open the whole constitution, the whole country of the needs of citizens. So it means that the real power in the country belongs to the citizens, not to the authorities, not to the Sejm, to the Senate, President, or Council of Ministers. The real power in the country is wasted by the citizens who decided about the country in the framework of the direct or indirect democracy. Of course, nowadays the indirect democracy played a crucial role. For example, through the election, we elected, of course, directly parliament, we elected directly president. The parliament chose the Council of Ministers. And when we can go to the next slide, as I told you before, our constitution guarantee that the parliament consists of the two chambers, Sejm and the Senate. And what is important, the position of the both chambers is not equal, like the United States. The Sejm, the first chamber of the Polish parliament, has a more important role, not only in the legislative process, but also in the scrutiny process. So when we have some difference between the both chambers, why our constitution established some kind of structure of the parliament? We are a unitary country like Indonesia. So we have no federation structure of the country, so it's very hard to find some understanding for choose this structure of the parliament. So why we choose bicameral parliament? Due to our history. When the parliament was created in Poland in 50th century, it was created and the king chose the structure of the two chambers. And during our whole history of constitutionalism in Poland, the Polish parliament consists of two chambers. Only during communist period, so directly after the Second World War, the communists decided to dissolve Senate, the second chamber. And it was signed that Poland is not fully independent. And after the transition period, when Poland started to be one more time fully independent country, not strictly connected with the USSR, one of the first decisions which was taken by the parliament was restore the Senate as a symbol of the independence. Of course, during work on the new constitution, it was a big discussion. Which role should play the Senate, the second chamber? Because we must looking for some justification for the role of the second chamber in the parliament. And they choose that the Senate will improve the legislative process. In theory, yes, but in practice, in many cases, when you have the same majority in the Sejm and the Senate, it doesn't work, unfortunately. After 1997, we have only one time situation when the political majority in the Sejm and the Senate was different. It was the last cadency of the parliament. And during those cadency, Senate blocked many initiatives of the first chamber of the Polish parliament. But nowadays, when we have the same situation that the same party has majority in the Sejm and the Senate, unfortunately, the role of take care about the quality of the legislative process doesn't work. So the the historic issue decided that we have the bicameral structure of the parliament, and their role are not equal like for example, Italy or United States. If we can go to the next slide, it's also underlined in the Constitution, in the provision of the Article 95, that the both chambers of the Polish Parliament participate in the legislative process. So, for example, Senate could propose some amendment, but Sejm, the first chamber, could veto there. So the role is not equal also in the legislative process. But what is the most important? The Constitution underlined that the control over activity of the Council of Ministers is wasted only by the Sejm, so by the first chamber of the Polish Parliament. Senate, the second chamber, has no control activity, no control instruments over Council of Ministers. Why? Because only Sejm, the first chamber of the Polish Parliament, participate in the procedure of creation of the Council of Ministers. If we can go after the legislation, the basic function of the Sejm is, of course, lawmaking process. In our regulation, we have a few fields of activity in which Constitution need the statutory regulation, that the acts will be regulated in the form of act. It's connected with the topic human rights, tax law, and criminal law. So all issues which are strictly connected with this issue need to be regulated in the form of act. And what is very important about the scrutiny function, if we can move 2 slides and one more. Okay. So, as I underlined, the scrutiny control is reserved only for the same. Of course, we have in the constitutional classical political responsibility of the Council of Ministers before the Sejm. So Sejm could prepare the motion on non-confidence at all time. It's not strictly restricted. We use the same solution like in the German Grundgesetz. So when the opposition would like to dismiss the government, must create a new government. So thanks that we have stability in this point of view. So it's very important change which was introduced in 1997, because at the beginning of the transition period, we don't have some regulation. And according to the small constitution from 1992, it was quite easy to dismiss the government. And during 1998 till 1997, we had over 9 governments, and some of government functioned for 5 months because the political situation was not so very stable. Nowadays, we have situation that the government work the whole cadency, or we have 2 examples, the government of Tusk and the government of Morawiecki, who take up power 2 cadency in a row, so it was not normal before 1997. Of course, the parliament play also a crucial role in the formative function. So the parliament appoint and dismiss very important person, constitutional bodies. If we can go to the next slide, of course the crucial role, it's connected with the appointment of the government. So in Poland we have maximum 3 steps to create the Council of Ministers. Generally everything finishes with the first step. In the first step, the government must be accepted by the Sejm, by the Polish first chamber of the parliament, by absolute majority of vote. If it doesn't work, after then the Sejm could choose the prime minister, and at least the president appoint the president of the Council of Ministers. If it will be also impossible, president dissolve the parliament. So it's also some instrument which ensure the stability of the political system. If we can analyze the appointment procedure, if we can go with the slide to the next, the Sejm, together with the Senate, appoints a lot of constitutional bodies in Poland. For example, they choose together the president of the Supreme Chamber of the Control, Commissioner for Citizens' Rights, Inspector General for Personal Data Protection. On the proposal from the President of the Republic of Poland, Sejm appoints the President of the National Bank of Poland. What is very important, the judges of the Constitutional Tribunal, they are also appointed by the Sejm. So please look at that Senate, the second chamber, doesn't participate in the procedure of appointing the constitutional judge. Also, the Tribunal of State, the judges who are the members of the Tribunal of States, they are also elected only by the Sejm. So it's also underlined that the constitutional position of the both legislative organs is not equal. If we can go further, as I told you before, the Senate has a right to initiate legislation and participates in the adoption of law. However, the opinion which is prepared by the Senate, an act by the same may be rejected by an absolute majority of votes cast at least of half a statutory number of deputies. If we can go further with the presentation, very important role Senate play only in the national-wide referendum. Senate could initiate the national-wide referendum and can accept or dismiss proposal prepared by the president. So always when president would like use the national-wide referendum to know the opinion of the society about very important topic, he always must prepare some motion to the Senate, and Senate should accept the motion or could dismiss. So it's very important competition which belongs only to the Senate, and it's only one of competition which try to improve the position of the president in our system. If we can go to the next slide. Also, Senate has right to appoint and dismiss the state authorities, which who told you before. The Senate also appoint and dismiss 2 senators to serve as members in National Council of Judiciary of Poland and the National Prosecutor Council, and the Senate choose also 2 members of the National Broadcasting Council, Council of the Institutional of National Remembrance, and 3 members of the National Policy Council. If we can go forward with the presentation, we move to the analysis of the position of the president in our system. The constitutional position of the president in Poland is a little bit strange, because on the one hand, president is a part of the executive branch in Poland. He plays a traditional role which played the head of state in the parliamentary cabinet system. But on the other hand, president has no strong position, not so strong position, not so strong competition, but he's elected directly by the nation. So it's a little bit strange situation, because usually in the parliamentary government system, president is elected by the National Assembly or some kind of mixed assembly who decided to elect president. But why president is elected directly in Poland? It's also connected with the history, especially 1989, 1990, when the democratic opposition decided to restore the position of the president in the Polish constitutional system, and after a short cadency of General Jaruzelski, when he resigned, the National Assembly decided to introduce the direct election of the president. And the first democratic president was elected, Lech Wałęsa. And when we give the power the nation, during the work on the constitution, it was very hard to move the power back to the parliament. So during the work on the new constitution, the parliament, the National Assembly decided to leave this procedure. It's very important because the presidential elections are the most popular in the Poland. So it's a curious situation. President has less power than the parliament, less power than the Council of Ministers. There has no real influence on our life like the local self-government, but the presidential elections are the most popular. So, for example, in the last presidential election, the turnover in the first and the second term was over 70%. So usually in Poland we are very happy when turnover was around 50-45, because unfortunately Polish people don't want to participate in the election. They don't want use the right to choose their representatives, and unfortunately always decided these people who stay at home. So around 10 millions of the Polish inhabitants, of Polish citizens, don't participate in the election, especially the parliamentary election, the presidential election. So it's a very sad situation, but unfortunately the government, the political class don't make anything with this big problem. So the president is elected directly to serve a 5-year cadency, and he can be re-elected only once. 2 times we have situation that the president was re-elected. First time President Aleksander Kwaśniewski, second time President Andrzej Duda. Pursuant the provision of our constitution, the president is elected by the absolute majority. If no candidate success in passing this, the hold a second round of voting is held with the participation of the 2 candidates with the largest and second largest number of the votes, which are the condition for the candidates of the President of the Republic of Poland. It must be the Polish citizens, be at least 35 years old on the day of the first rules of the election, and collects at least 100,000 signature of registered voters. At the next slide, you can see the photos of our all former presidents since the transition period. Starts with Lech Wałęsa, Aleksander Kwaśniewski, Lech Kaczyński, Bronisław Komorowski, Andrzej Duda, and our former president, Karol Nawrocki, who take the position in August 2025. Only 2 presidents were re-elected, Aleksander Kwaśniewski, and it's only, so Kwaśniewski was the only president who was elected in the first term. After the first cadency, when he started the second time, he won in the first round. After then, if we analyze the case of Andrzej Duda, he won the second time, but he needs the second turn to win the election. What is the role of president in Polish constitutional system? So according to our constitution, president shall be the supreme representative of the Republic of Poland and guarantor of the continuity of the state authority, and he should ensure the proper observance of the constitution, safeguard the sovereignty and security of the states. What it means? It means that the president create the international affairs, that he play a crucial role in our constitutional system? Of course, no. So according to the Polish Constitutional Tribunal, the role of the supreme representative of the Republic of Poland, it's strictly connected only with the traditional competence of the head of states. So we continue the tradition of the classical monarchy, like in the Great Britain, that the president is only the representative of the state. He is the first citizens, and with him is everything connected with the tradition of the nation, of the tradition of the country. So he couldn't play the crucial role in the internal or international affairs. This is domain of the Council of Ministers. Of course, the presidents who took the office in the past many times try to find some place to play more important role in the international affairs. This is one of the very tough competition between Council of Ministers and the President, and in the past and also nowadays we have some tension between Council of Ministers and President. We can observe it especially during the cohabitation period. Unfortunately, in Poland we have a lot of luck to cohabitation between the President and the Council of Ministers who representatives the opposite side, opposite parties. So on the since the beginning they would like to cooperate. So if they don't want to cooperate, so it's very hard to find some connection between them, especially in the international affairs. And it was one of the most important judgments of the Polish Constitutional Court, in which the Constitutional Court explained who played the crucial role in the most important fields, in the international affairs and the security and defense. And these both areas are reserved generally for the Council of Ministers. President could represent, of course, country outside, but he couldn't present his own policy. Unfortunately, we had some situation in the past when the Polish president represents Poland during the meeting of the Council of European Union, and also in the same meeting participate the Prime Minister, and they present different point of view. So it's not very good for some kind of big country which would like to play a crucial role in the European Union, that there are so big difference between their view of the international affairs. So when we can move to the next slide, our constitution also underlined which role president play in the international affairs. He ratified and renounced international agreements and shall notify the same and the Senate thereof, appoint and recall the plenipotentiary representatives of the Republic of Poland to other states or organization or international organization, and receive the letter of credence and recall of the diplomatic representatives of other states and international organizations accredited to him. So it's underlined strictly that it's the traditional competence of the head of states. So the Article 133 shows us that President is not a real creator of the international foreign affairs of our country. He could participate, he could represent Poland outside, but he is not a real creator of the Polish foreign affairs. And the second field of potential conflict, defense and security. The president, according to the constitution, is also commander-in-chief of the armed force of the Republic of Poland. But during the peace, the powers is weighed by the Minister of Defense. So it doesn't mean that president also create the defense policy. He could, for example, appoint the generals, he gives the old degree in the army, but he's not a military leader. So he doesn't create a defense policy. But, for example, during some celebration, of course, he participates as the head of states, and he is the symbol of the Republic of Poland. So he doesn't have a real power also in this field. And the third problematic issue connected with the judge nomination. Judges and the full professors are appointed in Poland also by the president. After the judges are appointed after the opinion of the National Judiciary Council. In the last 5 years, we had a lot of troubles with the constitutional status of the National Judiciary Council, but in the past it was a few cases in which president didn't accept the candidate who have the positive opinion of the National Judiciary Council. It was not only during the last cadency of Andrzej Duda, but also in the past, Aleksander Kwaśniewski, Lech Kaczyński also didn't accept the candidate for judges, although they have the positive assessment of the National Judiciary Council. Lucky in the procedure of appointment full professor, we have only one case in which president don't want to appoint a candidate who have a positive opinion of our National Excellence Council, and this researcher don't obtain the status of full professor because in his work he criticized a lot government and the president. So maybe when the person who serve as the president change, maybe it will be a chance for this professor. And what is important when we can move to the next slide, our constitution give also opportunity to build some cooperation bridge between the Council of Ministers and the President. So according to the Polish constitution, President can call the Cabinet Council. But it's not the Cabinet Council in which we know in the French system. The Cabinet Council doesn't have the competence of the Council of Ministers. It's only a forum to exchange the opinion about the most important issue. Because on the first eight, we were thinking that the Cabinet Council, it will be the same like in the France. No. It's only that the president would like to meet with the Council of Ministers and they would like to discuss about something. But they don't decide about anything. So they have no real power to take any formal decision which after then will be implemented in the past. If we can go forward, of course, president, like in the classic parliamentary cabinet system, doesn't respect the parliamentary accountability. Only the constitutional accountability and criminal accountability. So the constitutional accountability and criminal accountability, the crucial role play in this procedure the Tribunal of State for an infringement of the constitution or statute or for the commission of an offense. And it's very important that the formal motion could be prepared by the 140 members of the National Assembly. So they together, Sejm and the Senate, they create the National Assembly. 140 members could decide and prepare motion to accuse president before the Tribunal of the State. Lucky, till nowadays, it's never happened. So in the last year, the opposition, the Democratic and now majority would like to prepare some motion against the former president, but unfortunately it's not too easy to prepare some kind of motion. And now Council of Ministers. At the photo you can see the current government of Prime Minister Donald Tusk. It's the coalition cabinet, three main parties represented in the Polish parliament. As you see, the government is quite huge, so there are only constitutional ministers. Nowadays, when we take into account the whole numbers of the ministers, deputy ministers, and the Secretary of States in Poland, we have around 120 ministers. So it's a quite huge number of the government administration. If we can go to the next slide. So the cabinet consists of the Prime Minister, also known as the President of the Council of Ministers, or Premier in Polish, and ministers. If we can go further, the crucial role in the structure of the Council of Ministers play the Prime Minister. We use also the German solution in this case. So the Polish constitution of 1997 strengthened the position of the Prime Minister. So it's not typical primus inter pares like in the parliamentary cabinet system, but his position is a little bit strengthened like in the German chancellery system. So he presides over the Council of Ministers. He's monocratic and independent organs, and he represents Council of Ministers, manage the work of the Council of Ministers. At the photo you can see the first democratic Prime Minister of Poland, Prime Minister Tadeusz Mazowiecki. When Sejm chose him as the Prime Minister in 1989, it started the transition period, so he is the one of symbol of the transition in Poland. So if we can go further, the Council of Ministers, according to the Constitution, conduct the internal affairs and foreign policy of the Republic of Poland, conduct the affairs of states not reserved to other state organs or local governments. This provision is very important because give extra power to the government. Our constitution very rare use some kind of provision that give some extra open competence to the state organs. So generally the all competition are very restricted. They are expressed directly. Use this provision that conduct the affairs of state not reserved to other state organs or local government. It's also underlined the crucial role of the Council of Ministers in our system, and of course the government manage the government administration. And what it means exactly, this provision that the Council of Ministers conduct the international affairs and foreign policy. If we can move to the next slide, this provision was interpreted by the Constitutional Court, and the Polish Constitutional Court states that the European matter, being the subject of the session of the European Council, is primary matter which belongs to the traditionally understood internal affairs, and it's dedicated for the Council of Ministers. So it's especially competences which are dedicated for the Council of Ministers. If we can go further, of course, the government is politically responsible before, accountable before the Sejm. We have the classical procedure of the motion of confidence, motion on non-confidence, so it's very important issue which underline the crucial role of the Polish Parliament in the procedure of the political accountability. And a few words about the obligation of cooperation. So our Constitutional Tribunal underlines that the constitutional requirement of cooperation between President and the Council of Ministers regards foreign policy refers to the Prime Minister as the authority exercising the duties set out in the area of foreign policy, falling with the scope of activity and powers of the Council of Ministers.
You have 5 minutes more.
Okay. And Prime Minister cooperating with the President in respect of foreign policy exercise his power, and hence he acts within the scope of competence assigned to Council of Ministers in corpore, over which he presides, and not explicitly with the scope of the activity of powers and the Prime Ministers. So if we can move further to the Constitutional Court, till 2015 in Poland we have very stable situation because Constitutional Court played the crucial role as the guardian of the Constitution. But unfortunately, since 2015, the former government decided to make a big change. So he appointed a lot of judges. Part of them are elected on the position which was before elected, and thanks that create a new majority in the Constitutional Court, and the Constitutional Court tried to play a crucial role in informal change of constitution. In many cases, Constitutional Court changed the interpretation of the Constitution, and it was very dangerous. For example, they changed the meaning, the provision of Constitution connected with the members of the National Judiciary Council. because according to the Constitution, National Judiciary Council is composed from 15 judges. Generally, judges was in the past elected by the judges. Judges Assembly on the all levels choose their representatives, and after then, Law and Justice decided to introduce a new procedure, appointed the judges members by the parliament. So use the political tools, and it start our problem also with the European Union, and it start with the protest, the Polish society against this change. If we can go to with the slides to the photo, which show how the people protest. It's the slide with photo. We can go. Oh. It was the first protest in Poland in which the quite big number of the Polish society was involved. And the next slide, the most important sign of the protest, Constitution. So before the protest, before this whole situation, nobody in Poland talked about the Constitution. But thanks to the constitutional crisis which started in Poland in 2015, the word Constitution play a crucial role. As the constitutional lawyer, I'm very happy, but on the other hand, I'm very sad that we talk about the Polish Constitution only in this context of the constitutional crisis. So we are 2 years after the parliamentary election, but unfortunately we are still in the same place. So we didn't restore the rule of law in Poland due to the very tough cohabitation. So President blocked the all changes which are dedicated to restore of rule of law, and till they don't prepare any collaboration, if there will be no will to working together, unfortunately we will stay in the same point. So it will be impossible to make any changes and dissolve the whole institutional problem. So they are year by year growing, and we waiting what will happen in the future. So sometimes we laugh that maybe when we go retired, the situation will dissolve alone. Thank you very much for attention.
Teman-teman sekalian, tadi ada penyampaian yang disampaikan oleh Prof. Amaje. Sebenarnya hampir mirip dengan apa yang terjadi kepada kita. Ada presiden yang populis, ada mahkamah konstitusi, ada mengenai security. Saya akan coba untuk merespon dalam bahasa Inggris selama 10 menit. Prof. Amaje and our guest from the Poland. Our theme today, threats and challenges in constitutional law in the era of democracy, perspective from Poland in Indonesia. And as we already learned, that there is also very similarity between what happened in Indonesia and also in Poland. We have shared something in common. Friends, professor, lecturer, and all my students, we have each walked for long road from authoritarian rule toward democracy. Our history are different, but our question is the same. Our question is, how do we keep democracy firmly based on the constitutions? Poland is 15 hours away from us, and we still share the same story. What is constitutionalism? Modern democracy is not only about election. It's not only about changing the leaders. It's also about constitutionalisms, that we believe that everyone has in power must be limited by law. Everyone, including me, you, and all our leaders. The Constitution is not only a piece of paper, it's the highest political agreement between the state and its people. For you that be part of my class in Ilmu Negara or State Studies, you understand that the constitution is the agreement between the people and the country, and whether the leaders respect to that agreement. The constitutions ensure that power is used responsibly, that citizen rights are protected, and that justice is upheld. But in the past 20 years, 25 years, many democracy has faced a serious challenge. Poland in Indonesia may be fall to that category. We may see the rise of populism and new form of authoritarianism. Democracy can decline not through a sudden coup, but through a slow erosion of constitutional value, a process what we call constitutional backsliding. Indonesia experience, as you already know, that we already learned about 4 times that our constitution has been changed from 1999 until 2002. It's not only small technical change, but we reform the structure of political systems. From this reform, we make the new institutions, Constitutional Court, Regional Representative Council, or Judicial Commission. We establish Mahkamah Konstitusi, ada namanya Komisi Judicial, and also Dewan Perwakilan Daerah. The parliament getting stronger power of the legislation and oversight. The presidents began to be elected directly by the people. Together, this step make our presidential system more democratic and more stable. We have Constitutional Court as the guardian of the Constitution. But despite this institutional reform, we have not fully developed a constitutional culture. The challenge remains, and I believe the challenge what we have in Poland, it also happened in Indonesia. How we keep institutional integrity, how we keep political accountability, and how we enforce the court decision. The challenge of constitutional democracy, what I believe, we have 3 main challenges. And I think this is also happened in Indonesia and also it happened in Poland. And maybe please revise if I have different opinion, Prof. Maje. First, populism and constitutional decline. Populism often say the voice of the people is the voice of God. But in practice, populist leaders may use the slogan to weaken institutions that protect the people. A powerful government without proper oversight can slowly erode democracy using legal mechanisms that appear legitimate. That's the first problem. The second problem that we have to observe is judicial independence and judicial accountability. An independent judiciary is the heart of constitutional democracy, but independence must go hand in hand with accountability. Constitutional court must not live in isolation. They must remain transparent and open to public trust. And the third things that we have to observe is transparency and public participation. In many countries, lawmaking happens too quickly with little consultation, but real constitutionalism demands what we call it meaningful participation, atau yang biasa kita kenal dengan partisipasi bermakna, where citizens are involved not only at the end but from the beginning of policy making. And now in the digital era, new constitutional issues have emerged. We have also what we share from what Prof. Maje has informed of, data privacy, disinformation, defamation, and hate speech. Atau di dalam bahasa Indonesia kita mengenal disinformasi, fitnah, dan kebencian. This is not just technical question, but are the constitutional questions because they touch the balance between the freedom and responsibility. What we can learn from Poland and Indonesia from us for the two countries. Poland left communism in 1989. Indonesia ended the New Order regime in 1998. Both countries built democracy and strengthened the rule of law through constitutional reform. As you already learned from Maje, that we learned also about constitutional reform. But until today, we still face the new challenge from Indonesia and also in Poland. We learn from our experience that we learn an important lesson here. The lesson is the constitution can be weakened, not only by changing its text, but by changing the meaning of institution through power and interpretation. Undang-undang dasarnya tidak berubah, teman-teman. Kata-katanya tidak berubah. Tetapi apakah penafsirannya itu berubah? Itu yang perlu menjadi perhatian kita bersama. The text is not different, but the interpretations might be different. This is why we must always protect the independence of constitutional institutions, particularly when political interests are strong. Because at the end of the day, pada akhirnya, in the end of the day, democracy without respect for the constitution lose its meaning, and political stability without constitutional accountability is only a illusion. Sebuah demokrasi tanpa ada sebuah penghormatan kepada konstitusi itu akan kehilangan artinya. Friends, all the professor, lecturer, and all my students, from the story of Indonesia and Poland, we learn that democracy is never finished. It is a living process, a journey that requires vigilance, honesty, and courage. We must ensure that the Constitution remain our moral compass and our supreme law. Students and all friends, we have special responsibility to be the guardian of the constitutional reason, not only to understand the text, but to live by spirit and its value. I always say to you, all my students, constitutional reform is never complete. Every generation has the duty to protect it. So this is always stand for the people and for justice. Thank you very much. Terima kasih di Jafu Bardos. Jadi tadi dari speaker, sekarang balik lagi ke moderator ya. Oke teman-teman, so if you all have the question, we have time for question, 1 or 2 question to Prof. Macek. I give the floor. 1 or 2 question, we still have time. Yes, yang bagian belakang yang pakai baju putih dan yang kedua yang pakai jas yang depan. Silakan. Yang pakai baju putih, silakan ada mic-nya. Tolong sebutkan nama dan dari fakultas mana? Dari kelas mana maksudnya? Silakan.
Yeah. Thank you very much for the opportunity, Prof. Macet. I really am honored to be here because coincidentally I am also a constitutional concentrate student here at the Faculty of Law, so it's very insightful to know about the Constitution of Poland and the comparison of it with Indonesia's constitution. So, Professor, as you have said before, that there is a clear separation between the Sejm and Senate in Poland. My question is, how could such a strong bicameral system be implemented here in Indonesia? Because here in Indonesia, the People's Representative Council and the People's Consultative Council, or MPR and DPR, and the Regional Representative Council, or the DPD, still lack of a clear separation of power. And the DPD, as our senator or as a senatorial body, only has limited authority to give recommendations rather than make binding legislative decision. So I would like to ask that how does such a strong bicameral system can be implemented here in Indonesia? Thank you.
silakan yang kedua.
So my question is for Professor Masjid Sarvanich. I would like to have a question based on the topic before you used to discuss about communists between Poland and Indonesia. So my question is, what strategies did the government of Poland and Indonesia use to suppress or control opposition to communist rule, and how did these strategies impact society at large? Thank you very much.
Okay, so it's very deep. A question, Prof. Maje, is the first question is how about you try to balance between the chamber, and the second is very triggering questions. How is the government try to talk with the try to manage the opposition? Now is the time is yours.
Thank you very much for the question. So generally, I think also in Poland the position of the second chamber is not so very strong. So we always discuss when we start in our society discussion about the amendments of the constitution. One of the first topic is how to dissolve the Senate, because it's not strictly justified the working of the Senate. So during the work of the constitution, we try to find some place for the Senate, and we use the role of the legislative process. So maybe in Indonesia it will be also possible to improve the role of the second chamber in the legislative process, but it's, I think, better in countries, especially like Poland, when we are a unitary country. So we have no reason outside the historical to have the two chambers in our parliament. So when we take into account the financial issues, also the trust of the society to the political class, I think it will be better when in Poland we will have only one chamber. So I'm a bigger enthusiastic of the one monocratic terms of cadency, not cadency, but the chamber of the parliament. And the second question connected with the opposition and the communist period. So of course at the end of the 80s the situation was very tough in Poland, because the communists decided to introduce martial law in Poland, and those time was very tough for the opposition. So the opposition leaders were arrested, so they spent 2 or 3 years in the prisons. But after then, the communists start to thinking how to make agreement between the opposition and the communist government, because the biggest movement of the trade union, Solidarity, have over 10 million of inhabitants, of members. So it means that around 40% of Polish society belong to the Solidarity. So the movement was so strong that it was only two ways: make agreement with the opposition, or waiting when the USSR army come into Poland. So they don't need come into Poland because they were in Poland, because a lot of USSR troops were in Poland, so they moved from Poland in 1991. So it was a big success of the President Wałęsa when he make agreement with the USSR, and when the Soviet army moved from Poland. Nobody thought that it was so important decision when we take into account our current situation, when we have war in our neighbors. So in 1998 it was quite good atmosphere for make some kind of agreement, because also the economic situation was very terrible. So for the communists it was easier to make some agreement. When the economy collapsed, it was a big protest against them, And thanks the agreement which the communists make together with the opposition in the round table in Magdalenka, after 5 years, the post-communist party come back into power. So for many people, it was surprise situation that in country in which in 1989 the Solidarity movement won the first free election to the parliament. In the same, it was the contract election, so only 35% was elected freely. In the Senate, it was totally free election, and we have 100 senators. In this election, 100 senators was elected from the Solidarity movement and the old party who support the Solidarity. So it shows the communists that they lost, but they try to make agreements to stay in the political class, and after then, in 1993, they created the first government of post-communist party, and 1995, President Kwaśniewski, who was also the former member of the Communist Party, he was elected as the president. And he played a crucial role during work on our constitution. And what is the most funny situation? Till nowadays, the people thought, many people, that he was the best president. Although he comes from the Communist Party and he has communist history, so it shows that it's possible to make a change. He was a creator and visionary, thanks who Poland was a member of the European Union, NATO, but what is very important to underline one more time, and we have in Poland experience with that, it's really very important to secure the democracy. To thinking about the democracy it's not gift for the every time, yes? Every day you must thinking about democracy standards. In Poland we also fought. 1997 we have new constitution, we will have democratic standards, everything was done, okay, we are very happy. And after then come 2015, and step by step the populists start to introduce some part of the authoritarian system. And nobody believes that some change could happen, because we have a lot of instruments which safeguard the constitution, constitutional court, and so on and so on. But step by step they destroy everything, and it shows when the barbarian come into your garden, they will respect no rules. You can create a lot of rules, yes, regulation, but if someone don't want respect, he will destroy everything. So it's very important to have this in mind, that we must take care about democracy, about democratic standards every day. We observe what happened in America, we observe what happened in the Western countries, which also have a big problem with the populists. So it's very important to remember that democracy it's a crucial value of our life.
Thank you very much, and let us give applause to Prof. Maciek. Thank you, Prof. Maciek, for your insight and very honest information about what happened, and also how about the populist leaders. So when the populist leaders is not respect, and the people is also tense, not using the constitution as it should be. And teman-teman, terima kasih, and thank you for your interest, for your focus to our lecture today. And it is our learn about how is the two countries between Poland and Indonesia. We are still in progress. I think we are constitutionalism in progress, and this is the first and from many cooperations between two university. And thank you again for your visit, Prof. Maciek, and our friends from the Poland. Hope this is not your first and the last visit to Indonesia, and we will meet again, not maybe here or maybe in the Poland, and maybe through Zoom or through many activities again. And let's give applause back to the Prof. Maciek. Now I give back to the MC.
Thank you very much to Professor Maciej Serovaniec for such an insightful and thought-provoking presentation, and to Mr. Fritz Edward Siregar for his excellent moderation. Your discussion has truly deepened our understanding of the challenges and transformations facing constitutional law in the era of modern democracy, and has inspired us all to continue fostering meaningful academic exchange across borders. Before we conclude this session, we will proceed with the souvenir as a token appreciation. We kindly invite Professor Edi Pratomo, Professor Magdalena Barwiowek, Professor Maciej Serovaniec, Professor Arkadiusz Javen, Ms. Katarzyna Pawonka. For all the participants, please rise. Okay. To all the participants, you may sit again. Tutup. Berkotak. As we come to the end of today's program, we would like to express our deepest appreciation to all speakers, guests, and participants for being part of this meaningful academic exchange. May this collaboration bring fruitful result and continued friendship between Universitas Pancasila and Nicolaus Copernicus University. Thank you for your kind attention, have a pleasant day, and see you at our next event.